I want to go into and describe one measure which I have been promoting for some time behind closed doors with the government. I first articulated it in a summary way in July at a shadow cabinet meeting at which we had invited the Commissioner of Police and his team to attend, and I outlined it then as an approach which I think is much more suited to the problem they're trying to solve. It is a problem where, based on what they have said, there are approximately 300 known violence producers in the country. There's no reason why we have to suspend or infringe the basic human rights, the constitutional rights of half of the Jamaican population in the SOE areas that were declared in an attempt to deal with 300 violence producers. We need a tool that is designed to achieve that. I am of the view that pre-charge detention is warranted in Jamaica's present context in relation to known violence producers who have been identified by credible intelligence as posing a realistic danger of inflicting serious violence against one or more individuals or the community. A legal procedure can be developed and enacted quickly, whereby law enforcement can apply to the Supreme Court ex parte, that means without notice to the other side, providing supporting affidavits of the credible intelligence that justifies the immediate detention of this individual, and seeking a pre-charge detention order in order to protect against that credible risk of serious violence. The ex parte order, once granted, would allow 7 days initial detention, along with further 14-day extensions, up to 42 days of extension, 14 days at a time, subject at each interval, subject to law enforcement satisfying the court, again ex parte, that they are making progress towards building a case that can adequately support a criminal charge being laid against the detainee. The procedure, as I've said, would be limited in time, so that after 49 days from initial detention, the initial 7-day period, plus 42 days of extensions, 14 days at a time, after that 49-day period, the person must either have been charged or must be released. The affidavit evidence supporting the detention order would not be publicly available in a court file, but would be made available in redacted form to the detainee's defense counsel. Redacted meaning any sensitive information, names of witnesses and so on would be removed to protect vulnerable persons from any adverse action. To apply inter partes, that means giving notice to law enforcement, and the detained person would have the right during this period to apply inter partes, that means giving notice to law enforcement, apply to the court for his release, if he can satisfy the court that the detention is unwarranted and that he does not pose a credible threat of violence.
Informed, I'm Michelle Jones, and in the news, robbers beg for their lives on TikTok Live for guns seized. Please remember to subscribe, like, share, leave us a comment, and click the notification bell to receive our daily news items.
Officer, wait, officer.
Officer, hold on.
Come here, try to get to them, try to get to them, man.
Come out now, officer. Hold on. Officer, come out and do it. Do not kill them.
They kill you.
Let's slide over there.
Boy, they know.
Pull the door, officer.
Yo. Yo. I'll cook something for us. Let me hear that. Go on easy. It's a pint to the youth. Killer. Shut up, the youth. Keisha. 4 alleged robbers are now in custody after undoubtedly went live on TikTok after being apprehended by the police. Videos have emerged of several men pleading for their lives on a live stream.
Officer, please, me are begging you, officer. Please, officer. Me can change, officer. Me tell you, 10 pen me for go, officer. I swear to God, officer. Pilot me for the officer. Me not have the money, officer. I swear, officer. Please, officer. Me can change, officer. Me tell you, 10 pen me for go, officer. I swear to God, officer. Pilot me for the officer. Me not have the money, officer. I swear, officer.